Please be seated. We're here for oral argument in 1 SA 170186, State versus Brain, U, Real Party and Interest. These proceedings are being audio and video recorded, so we ask counsel to please identify yourselves and your client before you begin your argument. Each side is going to have 20 minutes. And Mr. Strange, you are responsible for watching the clock to determine if you want to reserve any portion of that time for rebuttal. Also, we have read the pleadings and we've discussed the case in conference. And counsel, you may proceed.
Your Honors, I'd like to begin by discussing the second issue that I raised in the petition, which in the end is the most important, because you have de novo review here, because it is a matter of statutory interpretation. That is the ultimate question. And that question is whether or not a crime of animal cruelty pursuant to 1329-10A9 can be a dangerous offense. The petition sets forth a number of reasons why the dangerous offense statute should be interpreted to allow that outcome. And that was directed at the arguments that were originally made in the motion that started this whole process.
Counsel, is that because an animal is sensible and is subject to being killed or subject to serious physical injury? Is that why the enhancement would apply? And the reason I ask that is, do you distinguish a case where you have a victim, so to speak, from a crime that wouldn't involve a victim?
Well, Your Honor, I bring up the point of the crime that doesn't involve a victim to show the error in the interpretation of the trial court, that it is necessary to add to a person to the dangerous instrument definition. I think that certainly animals can be seriously physically injured and can be killed, and so they fit under that definition of dangerous instrument capable of causing death or serious physical injury.
So would you distinguish that kind of case from a case where there wouldn't be a victim?
Well, for purposes of this question, I'm not sure that it would even come up. Purely because
if you took an inanimate object and you damaged it to such a degree that it would be a felony, and you use a dangerous instrument to do that, would, under the state's view, would you be able to enhance the offense?
I understand the question, Your Honor. And obviously you would not, for the pure reason that it would not be a dangerous instrument. There is no such thing as a dangerous instrument that can cause damage to an inanimate object, because an object becomes a dangerous instrument only in the manner that it's used, and that is capable in that manner of causing death or serious physical injury. Since an inanimate object can't be killed or suffer serious physical injury, you could beat that all day with anything you wanted, and that object would not be a dangerous instrument, and so therefore the dangerous offense enhancement would not apply.
But would your answer change if it was a deadly weapon? If I shoot a mailbox or something, a fence, and I ruin it, but I'm using a deadly weapon, not a dangerous instrument, because for whatever reason the legislature chose to use deadly weapon or dangerous instrument. So would it make a difference if it's a deadly weapon?
Well, I think that it obviously would, but I don't know for the purposes of this case if that is really something that would come up.
Well, it seems like what the state, if I'm understanding the state, that you're advocating that the entire first clause of the dangerous offense definition is not modified by on another person.
Correct.
So it's not modified at all. It doesn't say what it applies to. It doesn't say property, animal, person, according to the state's reading.
Well, and Your Honor, that's why I mentioned the crime of drive-by shooting in my petition. That's an example of a crime where you're using a deadly weapon, a firearm, and you shoot at a house. Now, that house may or may not be occupied at the time, but it is a dangerous offense. So certainly there are times when you use a gun, a firearm, or other deadly weapon, when an offense can be dangerous when it is directed at an inanimate object such as a house.
But isn't that inherent in the notion that it's a house and there might be people there? Like the case that talks about arson of an occupied structure.
Yes,
the
sir.
reason that at least in one case I saw that the court found that it would be dangerous is because it's an occupied structure by definition, like a residential burglary.
Correct, but the definition of occupied structure does not include people actually being in there. It's capable or likely to have people for the purposes of the arson case, Gatliff.
I guess an easier way to say it. So other than, are you aware of any case in Arizona where it's been applied to so you would submit that drive-by shooting is a victimless crime?
Well, not every time, but, no, because someone owns that house.
And they would be the victim?
Yes.
In all of these cases that you've cited that have been directed to our attention, hasn't there always been potential for injury to a person?
I would agree with that in the cases that I have cited, yes, Your Honor.
Okay. So let's take the crime of criminal damage.
Yes, sir.
In your view, could there be a case where the crime of criminal damage could be dangerous?
There could, Your Honor, yes.
And how would that happen?
Well,
Under a use of a gun or use of a dangerous instrument?
Well, I think it would have to be the use of a gun, because a dangerous instrument wouldn't be, unless in the instance that the respondent judge pointed out, the issue of a poisoning of a fish tank with bleach in his instance, where the fish are valued at greater than $1,000, that could be a felony dangerous offense.
If they were somebody else's fish?
Yes, if they were someone else's fish.
So doesn't that kind of raise just this absurdity that if you bleach your own fish, your own property, it's not only not dangerous, it's not even a crime, but if I bleach somebody else's fish, I've not only committed criminal damage, but it's dangerous criminal damage, and I could go to prison.
Well, Your Honor, when one considers absurdity, it often depends on whose ox is being gored.
Well, that may be
So
true.
whether or not that outcome is...
And under your theory, that would be dangerous if it was being an ox gored with a dangerous instrument, right?
Yes, it would be, Your Honor. That is correct. Assuming it, well, in that case, it would be anyone's ox, yours or anyone else's.
As long as it wasn't your own ox.
Well, actually, under animal cruelty,
Is
it
it
could
protracted
be your own.
suffering?
They're torturing the gored ox.
Yes. I think we're torturing this metaphor at this point. So, whether or not it's irrational, unnatural, or inconvenient, it's certainly odd. And I think the respondent judge came up with it thinking that no one would believe that that is an outcome that the legislature intended. But if you look at the entirety of the animal cruelty statute, the way that it operates, with only 5 of those being felonies, and only 2 of those felonies not involving service animals, one of which cannot be a dangerous, which is the cruel neglect subsection. So if you look at the way that operates, you look at the way the dangerous offense enhancement operates, and you do that analysis of the purpose, as I've done in the petition, you come up with the fact that the legislature set forth a series of escalating crimes. In fact, cruel mistreatment, if you recklessly cause cruel mistreatment, that is a misdemeanor. If you intentionally or knowingly cause cruel mistreatment, it becomes a felony. I would equate that to the aggravated assault statute. There are certain activities that are misdemeanors. There are certain activities that make those misdemeanors worse. It'd be aggravated assault, and there are certain of them that, if handled in a certain way, become dangerous. It's the same thing here. If you recklessly cause cruel mistreatment, it's a misdemeanor. If you intentionally or knowingly cause cruel mistreatment, it's a felony. And if you cause cruel mistreatment through the use of a deadly weapon or dangerous instrument, it becomes dangerous. It works exactly the same way as the aggravated assault statute, so there is precedent in the way that the legislature wrote these statutes
Mr. Strange,
for that to happen.
You have not cited, either side has cited, nor have we been able to locate any property crime that has been alleged as dangerousness and affirmed by an appellate court. Would you agree with that statement?
I would, Your Honor.
Okay. So
I assume that you haven't.
you're asking us to hold that property, and that's what a pet is, right?
Animals are property, yes.
Correct. So you're asking us to apply it towards property when in the 40 years that the current code has been in place, no, it has never been applied before?
Well, Your Honor, first of all, I would note that the animal cruelty statute was amended in 1999. Before that, it was never a felony and obviously couldn't be dangerous at that point. So it does limit that time range down from the 40 years that you mentioned. Additionally,
That's why I asked if it's still property. I mean, they've had criminal damages has been a felony under the code since '78, hasn't it?
well, and
Dangerous has been around as well.
correct. And I know of no case that says that animals are not property. But animals are certainly a different animal, for lack of a better term, than what we commonly think of as property. While animals are owned and they are property,
Well, they made the definition of property under the statute.
they do.
But,
And-
they are sensible property in that they can suffer serious physical injury and death.
And I would note that the very fact that they can suffer is what makes them different. And the legislature has acknowledged that they are different by setting forth a completely different statute of animal cruelty. Certainly, one could, if you had a very expensive dog, charge criminal damage. But I'm also unaware of any cases where, since the imposition of the new animal cruelty statute, where any state has filed a charge of criminal damage for damaging or defacing an animal. So I think that just by creating that separate category, by creating the animal cruelty statute, they have noted that while animals can be property, they are something different. They are, in many cases, sentient and can feel and suffer that pain, and it is that suffering that is ensconced in the A9 animal cruelty subsection: torture, unnecessary serious physical injury, or death through protracted suffering.
So, would the consequence of your argument though be, as Judge McMurray has asked you, would the state be able to allege dangerousness in other property crimes?
I don't believe that they would in 99.9%.
But that's exactly the point. I take your argument that if it's a dangerous instrument and you take your mailbox out into the desert and beat it, that wouldn't be dangerous. But under your answers to Judge Brown, if they take the same mailbox out into the desert where there are no people and he pulls out a deadly weapon and shoots it, then that becomes a dangerous offense then.
Assuming it's not his property, I would agree, but I don't think that's a consequence of the state's argument in this case. That is the way that the law is clearly written now, and nothing that this court is being asked to decide in this case would change that. This case does not involve a deadly weapon. It involves a dangerous instrument. And through a plain reading of the statute as it stands, yes, the use of a deadly weapon alone makes an offense dangerous. It does not require it to be used on a person.
Well, but let's back up and talk about a particular animal. So if someone is torturing an animal by shooting it, that's dangerous, and in your opinion, it would also be if they're beating it with a rod, those are both dangerous offenses.
Correct.
Right? So, but does that make any sense if you then take property and it's no longer sentient, but you're beating it to death with a sledgehammer versus if you're simply shooting it.
I don't know if it makes sense or not, Your Honor, but that's the way the statute is written.
Well, aren't we supposed to, when it's ambiguous, like I think this one is, we're trying to make sense and to make it read so it makes sense in all cases?
Well, I agree that there are, certainly that would be the goal, but I don't know that it's possible. And I would just have to go back to the point that the issues that you're raising with deadly weapon and the way that the statute is written are not at issue in this case and never have been. So it's an interesting question, and it is one that could come up one day, but it is not the issue here, and it won't be decided by this case.
But if we construe the statute, we can't construe it. Could we just say it applies to 132910, cruel mistreatment? We only decide that issue. How would we have to construe the statute?
No, I understand that.
By the legislature, and we have to say, this is what it means.
I'm not asking, I guess it depends on which statute you're talking about construing.
Dangerous offense.
So to go back to the original argument that was made and the discussion of whether or not that or is disjunctive, is that?
No, not that it's just disjunctive. Is what is the first clause? Assuming it is disjunctive, what does the first clause apply to? Property crimes, victimless crimes?
I think it is and always has applied to every crime.
Yeah.
Every crime that can be a dangerous offense, every felony.
But not DUIs, not felony DUIs.
Well, I don't know how you would commit a DUI with a deadly weapon because it requires a dangerous instrument.
You're driving a dangerous instrument, but it's my understanding that the Supreme Court has said, no, we're not going to go there. We're not going to go there. We're not going to allow dangerousness on a DUI because of the inherent nature.
Yeah, in Orduno, the Supreme Court specifically said they are dangerous instruments, but we're not going to allow them to be charged as a dangerous crime.
And I'm aware of that, but that, again, does not relate to...
I struggle with how they got that out of the plain reading of the statute.
Well, I don't think they did get it out of the plain reading of the statute, Your Honor. I think if you read that decision, it's obvious that they were seeking a result and found it. But if you start, as this court hopefully will, by just reading the plain language of the statute, it's not ambiguous.
Counsel, could the legislature make a reasonable distinction between deadly weapons and dangerous instruments and decide, any time that you use a deadly weapon, that's going to be a dangerous offense. And then, but we're also going to enhance the use of a dangerous instrument, but only if it's used under circumstances that could cause death or serious physical injury. So it wouldn't be unreasonable then to treat a deadly weapon differently than a dangerous instrument.
It wouldn't be unreasonable because one doesn't become a dangerous instrument until it is used. So I think that it's not unreasonable to treat them differently because one is, by definition, always a deadly weapon, but an object can't become a dangerous instrument until the manner that it's used. With the Court's permission, I'd like to keep the last 2 minutes.
All right, thank you, Mr. Strange. Mr. Allred.
Thank you, Your Honors, and may it please the Court. My name is Michael Albert III. I represent the real party in interest, Shandong Hu. I think when the State mentioned what the issue was here, it wasn't exactly clear that the issue the State is talking about is the issue in this case. And in my view, the issue is whether or not a dangerous offense whether or not animal cruelty can be a dangerous offense based upon the use of a dangerous instrument, specifically a dangerous instrument. This case does not involve a deadly weapon. and there's no allegation that the metal rod, if that's the way that we're going to describe the vacuum cleaner handle, is a deadly weapon. It's certainly not. It is the only potential is whether or not it could be a dangerous instrument. So when we go to the definition of dangerous offense and we read that definition, I think that some of the questions from this panel have highlighted exactly the problem with the way that the statute is, and which is that there is a difference between deadly weapon and dangerous instrument. Dangerous offense means an offense involving the discharge, use, or threatening exhibition of a deadly weapon or dangerous instrument, or the intentional or knowing infliction of serious physical injury on another person. So I think what the state is relying heavily on is that the or means another person only applies to the latter part of that sentence, which is serious physical injury.
But isn't that the normal construction we would take if we had no interpretation of this statute anywhere else? Mm-hmm. And we were just interpreting it for the first time. The placement of on another person after or, wouldn't that be the normal construction? We would
Yes, yes. I agree that that is the normal construction of the sentence. The issue, though,
why would we then not do that and place it now as what ultimately you want us to do, mm-hmm. to say that it's the use or threatening exhibition of a dangerous instrument on another person?
Because when you read the rest of the sentence, the first part of that sentence, and leave out another person, the definition becomes ambiguous. So we have to turn to the rules of statutory interpretation to define that statute. If you read it alone, a deadly weapon or dangerous instrument, you have to look through other definitions as to, okay, well, what is a dangerous instrument? A dangerous instrument means anything that under the circumstances in which it is used, attempted to be used, or threatened to be used is readily capable of causing death or serious physical injury.
But it doesn't specify a person, though.
It doesn't. That's true. It is silent on it. Again, creating another ambiguity, meaning the statute, the definition is ambiguous, and again, we have to turn to the rules of statutory interpretation to figure out what a dangerous instrument is. And I think the comment by the state a few moments ago was accurate in that an object doesn't become a dangerous instrument until it's used. So we have to know the manner it's used and what it's used on, I think is the most important thing. Is readily capable of causing death or serious physical injury to what? So that is what the respondent judge decided. In interpreting dangerous instrument and that definition, what has to suffer death or serious physical injury for this to become a dangerous instrument?
Well, and isn't that, wouldn't an answer to that be whatever is subject to death or that could suffer serious physical injury? And I think we all know that a person would satisfy that, but why wouldn't an animal satisfy that just as easily?
Because to open it up to anything, there are other live things aside from animals that could be subject to death based upon the use of an object. For example, the fish that the respondent judge used, that is not an animal, but subject to death. So it would open it up to that. In the judge's opinion, and I agree with that opinion, that is an absurd result. You could also take it outside of a fish.
You don't like fish?
What about plants? Can a plant to a tree?
And that's the next thing is trees, plants are living things. So if you were to take a chainsaw and cut down a $10,000 palm tree, certainly you would have that didn't belong to you. You would have a criminal damage that was a felony, and a chainsaw, in the manner it was used, created death to that palm tree. But certainly we would all agree that it would be absurd to think that that could be a dangerous offense where that person would be subject to prison. Or take like a saguaro cactus or other native Arizona plants. They are specifically protected by statutes that say if you...
But counsel, we can go on because we raised some of our own issues about that. But let's start off with the basic premise. Does the legislature have the authority to classify such cases as dangerous? Could they do that?
Well, if they did that, it would have to be in its own particular statute.
Why?
Well, because you can't read it into this definition in this statute.
Want us to read on a person into the statute.
Well,
But is there anything in the history of the statutes that would limit it? For example, the definition of serious physical injury doesn't have on a person.
right.
None of the definitional statutes other than dangerous offense has that limitation, right?
Right. So it's all
And
silent.
it's only limited by what you told me at the beginning. It only, by normal construction, would be limited to the intentional and knowing infliction of serious physical injury on another person. So by normal construction, we would only apply that one limitation on that one clause, but we wouldn't for all of the other definitional provisions because they're not there.
Right. And I think in an individual case, it may be necessary to go in and figure out what the legislature meant by each individual definition and leaving certain things silent. But in this case, what we have is the dangerous instrument definition being silent on what is the subject of being seriously injured or dying as a result of the object.
Or you could make the argument that simply when this was adopted in 1978, cruelty to animals was not a crime. So therefore, when they were making these statutes, they were only limiting it to human beings and not property.
Yes.
And then the addition of the cruelty to animal statutes, what was it, 98 or 99, somewhere around in there?
Right.
They didn't go back in and amend these definitions to necessarily include animals.
Right. And because they're not amended to specifically include animals, I think it would be inappropriate to read that in and make that animal a specific thing to be protected without the legislature's law stating so.
Even though you can read the language to do so.
Well, you'd have to, it's like the judge said, there's two different ways to interpret it. It's to a person or to anything, or what the state really wants is to write in to an animal. And that is a completely inappropriate way to interpret a statute, is just coming up with something to achieve a result and really supplanting, having this court, asking this court to supplant the legislature in writing the statute for the legislature. That's an inappropriate rule of statutory construction. So it really has to be interpreted in a way where you achieve the legislature's intent, where you avoid absurd or unconstitutional results. And I think the only way you can do that is the way that the respondent judge did in this case, was to apply it to a person. All other ways to interpret it, whether you say animal or whether you say anything, opens this statute up to absurd and unconstitutional results.
You keep saying that, but in what way? Because that's why I first asked you, because you mentioned that earlier in the pleadings. How is it unconstitutional? The legislature has the authority to do it.
If you open up the definition, like the panel was speaking about a moment ago, to say it applies to anything, even inanimate objects, I think you open the statute up to constitutional challenges if you allow, for example, somebody to take a sledgehammer and knock down a block wall worth $1,000 and have that be a criminal damage dangerous offense, subjecting that person to prison.
But again, going back to these are tricky, but I mean, again, that wouldn't qualify, would it? Because there would be no, it wouldn't be used to cause death or serious physical injury. I mean, a block wall can't suffer death or serious physical injury.
I think that's why interpreting the statute to say anything would be absurd.
Okay, but
that's
then
why.
you can go back to the tree example. The reason I think that the tree example might not work either is because serious physical injury includes physical injury that creates a reasonable risk of death. Oh, never mind. I take that back, because they have a risk of causing the death of the tree. So that could be a viable example. But I wanted to ask you a question about your interpretation of the statute again, as long as we're going here. How is murder a dangerous offense if a deadly weapon is involved, according to the states. If you apply the statute as the state would have it construed, and you look at a deadly weapon, which is not a dangerous instrument, a deadly weapon to intentionally kill another person. But again, I'm inserting the words another person. How do you construe the statute? Where does deadly weapon come from in a murder case?
I'm sorry, Your Honor. I'm not sure I understood.
Well, never mind. Forget that. I'd like to change. So what I'm struggling with here, and I think all of us are struggling with, is how would you, if you were writing this statute again, or if you had to punctuate it, or how would you write it so that it clearly applies to on another person, the whole definition?
Well, I think that to apply on another person to the whole definition runs into issues, because you do have situations and cases that say a deadly weapon can be used against an inanimate object and be dangerous. Unlawful discharge, for example, you have cases where deadly weapons, firearms, can be dangerous even if there's no victim, there's no person, there's no animal, there's no anything involved. So I think there's an issue with just cases and interpreting the statute that way. I think you have to make a distinction between the deadly weapon and the dangerous instrument, and essentially say that although a deadly weapon could be used to enhance a sentence and make it dangerous if there's an inanimate object involved in those cases or based on those statutes, because a dangerous instrument is unique in the sense that it's not inherently lethal or designed to be lethal, it only becomes a dangerous instrument in the manner in which it was used, that you have to take the object or the subject of that dangerous instrument to incorporate the definition of what dangerous instrument means. That it's just a unique statute in that sense.
Let's back up. If you take, maybe you, and if you find, I didn't see any cited. Do we have any cases that say use of a gun against a property, to commit a property crime like criminal damage, makes it dangerous?
Well, I think unlawful discharge of a firearm in city limits is a Class 6 felony, and that may be charged as dangerous just for the use of the firearm.
But
so there's not even another person.
Right, but
or,
that's because
or
of the
victim or
inherent part of the bullet coming down and hitting somebody.
That's true. I did look, and discharging a firearm into a residential structure, for example.
Again, but that's, I thought all of these crimes were based on the notion that they had the potential to cause harm to another person if you use the gun or the commission of the offense.
I think that's probably true. I can't think of a single statute in which some way a person or potential person wasn't somehow tied to the deadly weapon. I think that's accurate.
All right. So going back to the question that was asked you, how would you reconstruct this dangerous offense statute to make it read the way you want us to interpret it? Because you admitted that normally under normal construction, we wouldn't.
Well, I think the interpretation needs to be not necessarily on the dangerous offense statute, but we can't ignore that the interpretation, the ambiguous statute is really the dangerous instrument statute. That is the statute, that is the definition that the respondent judge.
The dangerous instruments?
Yes.
Okay. So I'm looking at it. So tell me.
How is it ambiguous?
Yeah, how is it ambiguous? You want us to add at the end of that sentence on another person, right?
I think what makes it ambiguous is that it's silent, capable of causing death or serious physical injury, and then it's just silent. So on what is the question, and that is what is ambiguous.
How's it ambiguous? And that's why it seems pretty straightforward to me.
Well, it could be anything. It could be animal. It could
Without
be
limitations, isn't that how we would normally construe it?
If we did, it would lead to absurd results, and we have to interpret statutes to avoid the absurd results.
Well,
The absurd result being the fish example, the tree example, a $1,000 ant farm or insect farm. The absurdities are endless if you say anything.
Are they absurd because we don't like the result, or you're saying that legislature couldn't possibly have intended that?
The legislature couldn't possibly have intended that.
So the legislature couldn't decide that we have some very valuable trees that we want to protect. So to protect them, we're going to make very hard penalties for the destruction of trees. I'm not saying that's what they did, but they could enact the statutes that way, and I don't see how that's absurd.
It's absurd because if that's the intent of the legislature is to protect certain plants or trees because they're so special, making a distinction about using a dangerous instrument to affect that tree is absurd. What difference does it make if I kick it over with my foot and kill it, or pull it out of the ground and kill it, versus chopping it down with an axe or a chainsaw?
Well,
that's absurd. It makes no difference.
Well, but that goes for anything. If you're the victim of a murder, you're dead, whether you're poisoned or stabbed or has a gun used.
Well, I think that the cases on the legislative intent of the dangerous offenses discuss that the use of a deadly weapon or dangerous instrument just make those offenses much more reprehensible. And it's not more reprehensible to cut down a tree with an axe or cut down a plant with a pair of shears versus pulling it out of the ground. There's nothing more reprehensible about that.
If you use a chainsaw that could create collateral damage, isn't that worse than using an axe? The legislature could think so, couldn't they?
I think if you're getting that far off, I think we've missed the legislature's intent in the dangerous instrument or deadly weapon definitions and why those are used to enhance sentences and make them mandatory prison and increase the minimum and maximum available sentences.
A question I should have asked at the beginning is the criminal code is a unified self-contained code, so everything should hang together and apply equally across its parts, and this is some reason not to. So, because animal cruelty offenses are in Title 13, and so are the two enhancements, generally speaking, why wouldn't the enhancements apply to the animal cruelty statutes?
Well, because when you look back to the definition of dangerous instrument and whether it applies to any statute in Title 13, you have to look at the definition, and it says capable of causing death or serious physical injury, but it stops there. So to find out if it applies to animal cruelty or any other statute in Title 13, you have to know what that subject is. And that's the only reason why we're trying to interpret whether an animal fits into that definition. And I think it's pretty clear that the respondent judge's interpretation is the only one that avoids absurd results by saying it applies to another person, because all the other options leads to absurd results in one way or another.
Thank you, counsel.
Thank you.
Mr. Strange.
Thank you. 3 points that I wanted to make. First, the respondent judge did not find that this result was absurd. He found that the legislature could not have intended it. just to note in his original ruling.
Isn't it the same thing?
I don't believe it is, Your Honor, because certainly there are times when something is not absurd, but the legislature didn't intend it. Second, I would note that there are no cases, the state has pointed, or the court has pointed out that there are no cases where a property crime has been seen as dangerous unless there's some inherent danger to people, such as arson of an occupied structure and drive-by shooting. There's also no cases that say that it couldn't be done, and that's probably because it hasn't been charged. It's not an issue that has come up. And if it does come up, then the court could look into that. But in this case, that's not the issue here. But
Speaking of haven't been charged, or maybe it is charged, and I'm just unaware of it. But taking the second clause of dangerous offense, intentional or knowing infliction. So if I break somebody's arm, or it has to be if I do something that causes permanent, whatever the definition, permanent health. I damage your arm so bad, using my bare hands, I damage your arm so badly that there's a permanent loss. Is that a dangerous offense?
if it qualifies as serious physical injury, yes, it would be, Your Honor. But not under
How do you get there?
Because a dangerous offense is involving intentional knowing infliction of serious physical injury on another person. Period. So it's not under the dangerous instrument definition.
Okay, you're not. There doesn't have to be any dangerous.
Correct.
But is it that charged in practice? Are you aware? I mean, where there hasn't been.
Yes. Where a serious physical injury makes something dangerous.
Yeah.
Yes.
But punching somebody and disforming their face.
Assuming that it can be proved to be serious physical injury, yes, Your Honor, that is charged.
Thank you.
I would just like to end by pointing out Gutierrez v. Fox. I did note it in my petition, but I think it's important given the discussion we've had today. When the legislature has specifically included a term in some places within a statute and excluded it in other places, courts will not read that term into sections from which it was excluded. This court decided that case. And on another person is contained in 13-105-13, the statute after dangerous instrument, and in physical injury, physical force, 13-105-32. So the legislature clearly knows how to do this if this was their intention, and they chose not to.
All right. Thank you very much, Mr. Strange.
Thank you.
Thank you both, counsel, for your arguments. The matter is taken under advisement, and a decision will issue in due course.